You know, in any democracy, there's this built-in push and pull, the people's will versus the law of the land. In India, this isn't just some abstract theory. It's been a real high-stakes tug-of-war for decades, playing out between Parliament and the Supreme Court. And it really all boils down to one massive question.
So, who should have the final say on India's constitution? Should it be the Parliament, the people we elect to represent us? Or should it be the Supreme Court, the unelected guardians of the Constitution? It might sound simple, but believe me, the answer to that question has shaped India's entire legal and political world for more than 70 years.
All right, to really get this, we've got to rewind the clock. Let's go all the way back to the beginning, the early 1950s. India is a brand new republic, right? The focus is all on building a nation from the ground up. And back then, let me tell you, the scales of power were definitely not balanced.
So in the early days, the Supreme Court was, well, pretty literal. Take the A.K. Gopalan case. The court looked at this phrase, procedure established by law, and basically said, hey, as long as Parliament dots its I's and crosses its T's when passing a law, it's a valid law. Whether the law itself was fair or just, didn't matter. This pretty much handed the government a blank check to limit personal freedoms.
And if there was any doubt, it was erased just a year later. In a case called Shankari Prasad, the court laid it all out, crystal clear. They said Parliament's power to amend the Constitution was absolute. And when they said absolute, they meant it. They could change any part, even the fundamental rights we hold so dear. For a hot minute there, it really seemed like Parliament was completely unstoppable.
But things were about to change. That constitutional pendulum, it was starting to swing back. After years of kind of taking a back seat, the Supreme Court was about to stand up and challenge Parliament's total power, and they were going to do it in a way that absolutely nobody saw coming.
And that big moment, it came in the Golok Nath case. The court did a complete 180 on its earlier ruling. They declared that fundamental rights weren't just ordinary laws. They held this special, almost sacred status. They were, in the court's words, transcendental and immutable. What does that mean? It means they were now off limits. Parliament couldn't touch them. A line in the sand had been drawn. Big time.
You can imagine the chaos this caused, right? It was a full-blown constitutional crisis. On one side, you've got the elected parliament saying, hey, we can change whatever we want. And on the other, you've got the Supreme Court putting its foot down and saying, nope, not these core rights you can't. The stage was officially set for the ultimate showdown.
And all of this tension, this deadlock, it was all leading to one place, the climax of our entire story, the Keshavananda Bharati case in 1973. And this was not just another court case. This was the hearing, the one that was going to decide the very future of democracy in India.
Just to give you a sense of how huge this was, to sort this mess out, the Supreme Court put together its largest bench ever. 13 judges. Think about that. 13 of the country's top legal minds, all gathered for one monumental task, to finally answer that one big question. Who really holds the power? And the answer they came up with? It was brilliant. It's called the Basic Structure Doctrine. Think of it like this. It's a compromise. The court said, okay, Parliament, you can amend the Constitution, you can renovate the House, but you can't knock down the foundation. That foundation, that's the basic structure. Core ideas like democracy, the rule of law, things like that, those are untouchable.
So this wasn't just the end of the fight. It was actually a whole new beginning. Because now, armed with this powerful new tool, the basic structure doctrine, the court could do more than just play defense. It could go on the offense. Not just protecting fundamental rights, but actually expanding what they mean in ways that would literally change Indian society forever.
Let's look at a perfect example. Article 21, the right to life. Remember back in the Gopalan case, it was just a narrow procedural thing? Well, fast forward to the Meena Gandhi case. The court looked at it again and said, hold on, procedure doesn't just mean you followed the steps. The steps themselves have to be fair, just, and reasonable. That single change was a game changer. It turned Article 21 into this incredible source for all kinds of human rights. And they just kept building on that idea. The court started to expand its reach even further. In the famous Olga Tellis case, they said, look, what's the point of a right to life if you don't have a right to livelihood? It's a landmark decision that protected the homes of pavement dwellers because the court recognized you can't really live a life of dignity without the basic means to support yourself. And this logic isn't stuck in the past. Decades later, in 2017, the court did something huge. It declared that the right to privacy is a fundamental part of the right to life. Now, this wasn't just some nice idea. It became a crucial shield for every single one of us, especially in the super-intrusive digital world we live in now.
And it just keeps evolving. I mean, as recently as 2020, in the Honorata Boston case, the court looked at our modern, connected world and said, you know what? Freedom of speech today is tied directly to having internet access. So they affirmed that access to the internet is a fundamental right. It's a perfect example of how the Constitution is kept alive and relevant for the 21st century.
Okay, so why is this history lesson so important for us today? Because this whole constitutional tug-of-war, it's not over. It's not some dusty old story. It's a living, breathing conversation that is still shaping India as we speak. That basic structure doctrine is still the Supreme Court's most powerful tool. It's what they've used to recognize transgender persons as a third gender, to strike down unfair practices like instant triple talaq, and, as we just saw, to protect our digital freedoms. It's the mechanism that makes sure our Constitution is a living document, one that can adapt to new challenges while keeping its core soul intact.
And that brings us right back to where we started. The tug-of-war goes on. New challenges are popping up all the time. So the real question isn't just about who holds the power anymore. It's about how that power will be used to protect the fundamental ideas of liberty and justice for everyone. And as our society keeps changing, you have to wonder, what's the next big thing? What core principle will the court be called on to protect next?